When and how should the judicial branch use its power to strike down laws? This is one of the most basic questions of American law. In the course of answering it, we're going to talk about what has been called the most famous footnote in history, Footnote 4 of United States v. Caroline Products, 1938. In a previous lecture, we discussed the Caroline Products case, the case upholding a ban on filled milk. Recall that in this case, which came as a reaction against the judicial overreach of the Lochner era, the court developed the rational basis test. Under this test, as long as one of the other branches had a rational basis for enacting a policy, it would be upheld. After the excesses of the Lochner era, rational basis represented a move towards judicial self-restraint. At the time, some commentators thought the court had practically removed itself from American life. What will the court even do anymore, they asked. Buried in a footnote of Caroline Products, Footnote 4, Justice Harlan Stone had a vision for a new role for the judiciary, a role that should seem familiar to us today. Simply put, there are some laws we should be more worried about than others. Footnote 4 supposes a two-track system of judicial review. Actually, there are more than two standards of review, but we'll simplify to two. Some types of laws, such as speech censorship, voting restrictions, and racial classifications, should be inspected very carefully by the courts. The court uses a difficult test, what is called strict scrutiny, to see if such laws can survive. However, other laws should be allowed to slide by without close examination. In fact, the vast majority of laws, for example a ban on filled milk, should be upheld easily as long as Congress gives some rational reason for its action. This is the rational basis track. This two-tiered system of judicial review makes intuitive sense. But is there a principled way for the court to make this distinction? To examine some types of laws closely and let others, however flawed, slide by? Justice Stone thought there was, and his reasoning goes back to the fundamental problems in democracy itself. For convenience, I will call this the Federalist fear and the Anti-Federalist fear, for these are basically the two ways democracy can go wrong. The Anti-Federalist fear, as we recall, is that government will become detached from the will of the people. The Anti-Federalists are tyrannophobes who fear one or a few citizens seizing power. In particular, they are concerned that politicians, once elected, will stop listening to the people who voted them into office. They will, as the saying goes, kick down the ladder by which they rose. Instead, these politicians will act only in their own interest. In short, the first problem in democracy is, how do we get representatives to govern in the interest of the people? The second problem with democracy, the Federalist fear, is practically the opposite, that representatives do listen closely to the people, and that's the problem. For to the Federalists, those people are often mistaken, volatile, and unfair to minorities. The Federalist is particularly concerned about the problem of majority tyranny. Democracy can be brutal to the small numbers of people outnumbered at the ballot box, like the Loyalists in the American Revolution. The genius of Justice Stone's Footnote 4 is that it recognizes and builds its theory on both of these problems. Stone's answer is that the court is in the best position to solve both the Anti-Federalist and the Federalist problem. Justice Stone says that for most laws, rational basis is the norm. Again, we have no problem if Congress wants to ban filled milk. However, there are two situations that call for a more searching judicial inquiry. First, legislation that restricts the political process, and second, discrimination against minorities. First, says Footnote 4, legislation which restricts those political processes which can ordinarily be expected to bring about repeal of undesirable legislation may be subjected to more exacting judicial scrutiny. Ordinarily, if Congress passes a bad law, the solution would be to vote them out in the next election. However, what if that law itself makes it harder for the people to speak, vote, or participate in that election? Take something like the Sedition Act of 1798. The Federalist Party outlawed criticism of top government leaders, and those who spoke out against, say, John Adams, could be jailed. The risk is this makes it easier for them to win the next election. It didn't work out that way for the Federalist Party, but the danger is there. If the government censors speech or tampers with the rules of voting, you might get a government that makes itself immune to the people, that entrenches itself and locks in its own power. This is the anti-federalist fear. An excellent case can be made that this is what is going on with gerrymandering, by the way. The winning party draws the map, which causes them to win the next few elections and stay in power when it's time to redraw the maps, short-circuiting public opinion altogether. Footnote 4 says that it's exactly these types of problems that call on the court to act. The court should be particularly attuned to violations of speech, associational, and voting rights. Those rights by which the people express their will and make legitimate all other government activity. The image is of the court as a plumber, keeping the pipes of representation clean by ensuring open debate and fair elections. In this sense, the court can actually assist in majority rule. Second, footnote 4 addresses the Federalist fear. It states, "Prejudice against discrete and insular minorities may be a special condition which tends seriously to curtail the operation of those political processes ordinarily to be relied upon to protect minorities, and which may call for a correspondingly more searching judicial inquiry." In the phrase discrete and insular minorities, discrete means distinct and definable, and insular means politically isolated. Ordinarily, we rely on our Madisonian model, the filtration of talent and the division of power, to give minorities political opportunities. But Justice Stone is saying this may not be enough, and it is particularly the virtue of the Supreme Court that it does not stand for election, and therefore is free to help out those who would be outnumbered in the democratic process. Here, the imagery to keep in mind is the court as a shield to be wielded against majorities in the other branches or the states. In this function, we say that courts play a counter-majoritarian role. In the decades shortly after Caroline products, the ideas in footnote 4 would soon be put to use. For example, there was a series of cases protecting the rights of the discrete and insular Jehovah's Witnesses, notably West Virginia v. Barnett, the case where the schoolchildren were not forced to salute the flag. And of course, the most famous counter-majoritarian case of all time is Brown v. Board, where the court did what neither Congress, nor the President, nor least of all the southern states would do, and invalidate Jim Crow laws. Of course, the court needed the other branch's help enforcing its decisions, as we've already seen. Footnote 4 of Caroline Products is just a footnote, technically judicial dicta, not even relevant to the case at hand. The first time its ideas make it out of a footnote and into the core of an opinion is actually the Korematsu case, of all places. Korematsu v. United States is the infamous case in which the Supreme Court upheld FDR's Japanese internment program during World War II, when innocent Japanese Americans on the West Coast, even those who were U.S. citizens, were forced into camps and put under military supervision on the theory they might sabotage the war effort, based on no evidence besides their parentage. It was FDR's lowest moment, and the Korematsu case upholding this program is universally considered one of the worst decisions in history, part of the anti-canon. And yet even in this unlikely case, the court took an important step towards strict scrutiny for racial discrimination. Echoing footnote 4, Justice Hugo Black writes, "All legal restrictions which curtail the civil rights of a single racial group must be subjected to the most rigid scrutiny. Pressing public necessity may sometimes justify such restrictions, but racial antagonism never can." Now, of course, the court upheld Japanese internment because they said World War II was public necessity. With the benefit of hindsight, we can say that they were wrong and it was racial antagonism, but at least the court had the right general idea, even if they applied it wrong. To summarize, Justice Stone's footnote 4 is an important framework for considering when the judicial branch should be active and use strict scrutiny, versus when it should use the rational basis test and take a more hands-off approach. Under Justice Stone's theory, the judiciary should advance two basic goals. First, it should assist in majority rule by protecting speech and the election process. Second, it should protect minority rights for discrete and insular minorities, above all, racial minorities. But when neither minority rights nor the electoral process are at stake, the court should give deference to the legislature. For example, if only commercial regulations are at stake, like a ban on filled milk, the affected parties should use the democratic process, not the courts, to voice their dissatisfaction. Instead of strict scrutiny, the court should use the lenient rational basis review in these cases. When the court follows it, the system of tiers of scrutiny advances democratic goals while mitigating the risk of a runaway court.